Good afternoon and welcome to the follow-up session to the webinar held on the 23rd of April 2021 relating to the Child Justice Act 2008, Act 75, I think, if I'm not mistaken.
75 okay. Of 2000.
Thank you, Dr. Badenhorst. So the session now that we are finalizing is just the questions that were posed during that webinar presentation. And we want to thank Dr. Badenhorst for availing her time once again to answer these questions and for a very, very informative presentation on the 23rd. The amount of interest that has sparked and the questions that were asked really indicate the amount of interest around this particular topic. So thank you once again, Dr. Badenhorst, and for sharing your expertise with us on the 23rd. Thank you.
Pleasure.
So welcome once again. We will just go through the questions that were posed on the day, and we will get Dr. Badenhorst's response to those. Okay. Thank you. So the first question that was asked was by Miriam Abbas from Falkenberg Psychiatric Hospital. And her question was to clarify an 11-year-old boy being the middle person fetching the cannabis from the house to the person buying in the street from his grandfather would not be prosecutable if arrested.
Okay, so first of all, I just want to clarify that the judgment that I discussed during the presentation referred to a Gauteng South judgment. So we are still waiting for confirmation from the Constitutional Court. So in law, it's still an offence for a child to be using or possessing cannabis. But the court have also indicated that children should not be arrested in the meantime, waiting the processes to unfold. And that's the only offence, if I can say, which this judgment addressed. So if a child sells cannabis to someone, they can still be arrested and prosecuted. And the same goes for transporting it on behalf of another person. But the Child Justice Act also acknowledged that children may be used by others to commit a crime. And that is one of the factors that the court will take into account when such a child appears before the court. The probation officer will investigate that. They will put the information that they have to their disposal in the assessment report, and the court will then inquire as to, you know, the circumstances of this, and the child in that circumstances may be regarded as a child in need of care and protection because he's doing it because he doesn't have he can't sustain himself, or he doesn't have a family too. So it depends on who's using him, and also there's no distinction. It can be an older child as well using a younger child to commit a crime. So it's not only being used by an adult, but it's definitely something that the court will take into account. But the child may be arrested for that because that is still an offence.
Okay, it's very interesting. If we look at a situation where the older child is the person that has hired, if we can use that word, the younger child, what prosecution does the older child face if that's in a situation like that? Do they also fall under this what you are talking about, or would they be prosecuted?
They will be prosecuted. The Children's Act number 38 of 2005 does make it an offence for any person to use a child in the commissioning of an offence. So the penalties, so it's a separate offence. So the older child can be then charged with dealing in substances or in drugs or cannabis or whatever, but the additional charge will then using a child to commit a crime, and the penalties for that is quite stiff.
Okay, all right, thank you. That clarifies it, because I think it's evident from what is happening in South Africa at the moment that we are experiencing an increase in teenagers who are employing younger children to do such activities for them. And it's quite interesting to note that those older children can be charged with that. So thank you.
Yes, and there is an obligation on any officer of the court who becomes aware that a child has been used by an older child or by another person, that will then include older children and adults, to report that to the police. And as I said, that is a separate offence to be charged with.
Thank you. Thank you. All right, so if we move to the next question was posed by Cheryl Blackenberg. Is this act doing what it is supposed to do, and who monitors the implementation of this act? Is it the courts, correctional services, law enforcement, social development, or all of these? On what basis does the legislation protect youth?
Okay, so basically the monitoring of the implementation of the Act is provided for in the Act. Section 94 of the Act, it establishes an intersectoral committee which comprises of the Directors General of the Department of Social Development, the Department of Justice and Constitutional Development, the Department of Health, the Department of Education, the Correctional Services, the police, the national and the National Prosecuting Authority. So it's the heads of those departments that comprises this intersectoral committee, and the responsibilities in terms of Section 96 includes the monitoring of the implementation of the Act, and also to ensure that all the relevant data are being gathered, you know, so that we can have a good sense of how children move through the system. And then another responsibility on this committee is to develop annual reports on the implementation of the Child Justice Act that must be tabled in Parliament. So Parliament will then also have an oversight role to play in the implementation. We have to table those reports every year, annually, and then we are called to the select committee and the portfolio committee to come and brief them on the implementation of the Act. So there is quite a number of monitoring on the implementation of the Act. So it's the responsibility of all these departments, because we are all responsible for the implementation of the Act. The Minister of Justice and Correctional Services plays the political head, you know, is the political head in terms of the implementation or the administration of the Act, because the Act falls within the Department of Justice and Constitutional Development.
Okay, so there is a quite a large amount of monitoring in terms of the implementation, and yes. Those reports, you say, are presented annually to Parliament. Are they only presented to Parliament, or are they ever made public to the citizens?
Okay, so the moment a document is tabled in Parliament, it becomes a public document. So all these annual reports are accessible through the Parliament's website. You know, so everyone can have a look at them. And the non-governmental organizations also plays a huge role in overseeing the implementation of the Act. They are part of our committee. So we've got the intersectoral committee. Then we also have on national level, we have departments that, you know, all these departments are on national level, meeting on a regular basis bi-monthly to discuss the implementation. And this is then mirrored or duplicated in all the provinces. So there's these structures that feeds into each other to ensure that provincial implementation is monitored nationally, and as well then on DG's level and Parliament. Yes.
Okay, thank you. Thank you. Let's move on to the next question. The next question was also posed by Cheryl Blackenberg, and that question was, who benefits from this act, children or youth, and on what basis?
Okay, so basically, one of the aims of the Act, or the aim of the Act, is basically to ensure that we create safer communities, because we want to break the cycle of crime in communities, and thereby assisting children to become productive, law-abiding citizens. So that's where the option of diversion plays a huge role, because we want to protect children from the adverse effect of the criminal justice system in all cases where it's possible. And we also, the Act also encourages rehabilitation and reintegration of children back into the communities and into their families, which will then minimize the risk of reoffending. And also the Act has a very a huge emphasis on restorative justice, for children to take accountability and responsibility for their offences, but then also to include the victims and the communities into dealing with these children, so that they can make amends for the harm that they've caused in the community. So basically, it benefits the communities, it benefits society, and it benefits the children. And that is the way that the Act is being portrayed, you know, through the guiding principles, the objects, and the aim of the Act throughout the whole system.
Thank you. Thank you. If we move to the next question, the last question posed by Cheryl was, what happens if a child at around about the age of 15 commits a crime but is found to be intellectually disabled, or that child is found in with possession of cannabis? What is the common recommendation in this situation?
So basically, the criminal capacity that I was referring to in the presentation related to a child's ability or capacity to distinguish between right and wrong in relation to their age. So if you have a 10 to under 14-year-old, that is something that you must additionally prove before the child can be convicted. So it's a consideration that happens with each and every child. So if a child then reaches 14, you may find that a child may not appreciate the difference between right and wrong, and that is because they've got a mental illness or a mental disability, or and in that regard, we intellectual disability. So in that regard, the Criminal Procedure Act kicks in. So you get section 77, 78, and 79. So if the court then becomes aware that this child may not have the capacity to distinguish between right and wrong, and to act in accordance with that because they have a mental intellectual disability or a mental illness, the court can refer this child to a panel of psychologists and psychiatrists. The process is being explained in the Criminal Procedure Act, which will then give a report to the court whether they feel that this child can be held responsible because of the special circumstances of the child, referring to his mental health. And in that regard, if that is then the case, the court will not convict that child. And if the child has already been convicted, and only after conviction they've realized that this may be the issue, the conviction is then set aside. So then the court will decide, you know, what to do with this child. And the Criminal Procedure Act was amended in the past year or two to specifically cater for children. So in the past, you had very limited options what to do if the child now has committed offense, but due to a mental illness or intellectual disability, you know, should not be convicted or be criminally in the criminal system. And the Criminal Procedure Act was then amended to provide that such a child can be referred to the children's court as well, or can be released on conditions into the care of the parent, or on or without conditions. So basically, it's to protect children then, to ensure that they don't end up in a mental health facility, but that there are special procedures in place to deal with these children. So the Children's Court will then also do an inquiry and decide how to deal with this child, but that will be also outside of the criminal justice system. So not to put a child in a mental health institution for an undetermined period of time.
So essentially that assessment that you were talking about is so vitally important when dealing with the children in the system.
Yes, so basically that's something that the probation officer may pick up and alert the court to, you know, in the initial assessment. So basically you get the initial assessment by the probation officer. If the child is between 10 and under 14, you'll have the criminal capacity due to the young age of the child, which will then be considered. If the child is over 14, then the mental illness or intellectual disability issue can then be raised to ensure that those children also get the necessary protection. Yes.
Great, thank you, thank you. All right, if we move on to the next question, was posed by Tanya Calve, and she asks, what are the laws and actions regarding minors drinking alcohol? Because children and adults are not equal with regards to the detrimental effects of cannabis use on the developing brain.
Okay, so basically, the National Liquors Act do not criminalize children for using alcohol. You can, you know, children are not charged in courts if the police, you know, see them drinking alcohol wherever, in the streets or at taverns or whatever. They cannot be criminally, they are not criminally charged, but those children should then be, you know, be brought to the attention of the social worker through because they may be addicted to alcohol and then maybe a child in need of care and protection. So the processes I referred earlier to in terms of the national instructions of the police 3 of 2010, the Children's Act will then kick in because the child will be brought to the attention of a social worker who will then have to do an investigation. So, but what the police also then do, and that relates to tobacco and alcohol, both of them are the same. You know, children are not charged for any of those, is to interview the child to find out where did they get it, and then to you know, approach or apprehend those that supplied it to the child. So, so we don't criminalize the child for that, but the idea is then to concentrate on those supplying it to the child. But the National Liquor Act also, as I indicated with the issue of cannabis, if a child sells it or you know, gives it to another child, that is still an offence. So if they have it and they drink it, you know, they cannot be charged. But the moment they give it to another child or they sell it, or then it will still remain offence, and which they can be charged for.
Okay, so I mean, if they're in just in possession of it, they can't be charged. But if they were in possession and influencing others, or giving it to others and selling it to others, yes, then that becomes an offence that is chargeable.
Definitely, definitely, yes. And with the judgment that we do have now and waiting for confirmation from the Constitutional Court, we will have to strengthen this this early intervention from the police's side to ensure that we not only focus on children using cannabis to bring them into the system through the social worker, but also focus on children using tobacco and children using alcohol, because I think that has been left really, you know, the focus have never been really on that. So hopefully by strengthening those structures and those processes, we will also be able to then, you know, include and focus on children using alcohol and those smoking tobacco.
Absolutely. I think you raise a very, very important point there, because alcohol and tobacco uses has often been overlooked in terms of the youth, but there's so much interest or so much out there now about the cannabis use, that perhaps this is an ideal time to revisit the alcohol and tobacco use in youth as well.
Yes, yes, and to include them into that safety net that we'll now have to create for cannabis. Yes, I agree.
Thank you. That's great. Let me move on to our final question before we go on to the comments, and just to get some points from you. The question here was posed by Sophia Stadler from Department of Social Development. She says, good afternoon. She agrees with Erica, and unfortunately there's a lot of different understanding around criminal capacity, the roles and responsibilities of the PO, the MPO, the MPA, the DOJ, assessment reports, etc. Who is really supposed to do what?
Okay, so basically, as the Act stands now, the probation officer is expected to provide a recommendation or a statement on whether they think this child do have the necessary. So we're talking about the 10 to under 14s here, whether this child have criminal capacity. And it's just basically a recommendation or indication and indicating what she thinks that should be taken into consideration when the court makes such a decision. So that's basically where the duty of the probation officer stops in this specific regard, with regard to criminal capacity. We have had indications from probation officers that they have difficulty with this issue, because they have never been trained. And the issue of criminal capacity is purely a specialized field, you know, and that's why those that have been identified to do the evaluation is psychologists and psychiatrists. So it's quite difficult for probation officers to really you know, make a recommendation or input in that regard. So the next is then the NPA. So before an NPA a prosecutor decides whether or not to proceed with the charges against the child, they also have to consider whether they will likely be able to prove criminal capacity, because it's one of the elements, as I said, that the state must prove beyond reasonable doubt. So if the prosecutor, when reading the assessment report or looking at the circumstances of the case, they may decide, you know what, I'm not going to be able to prove criminal capacity, and then not proceed with the case on that basis. So if the prosecutor is quite confident that they will be able to prove criminal capacity, and they decide not to divert the matter but to take it to court, the next step is then for the court. So the prosecutor, the legal representative, can apply for a criminal capacity evaluation by a suitably qualified person, or the court can do it out of its own violation to decide, okay, I'm not sure if this child, I want a professional to give me a professional opinion on this. So so that's basically the court's responsibility then to get that report from the psychologist or psychiatrist, and then to make a decision based on all the circumstances of the case, and this report received from the suitably qualified professional. And then if the court decides there is criminal capacity, you know, it's fine. If not, then the child cannot be convicted for the crime, because that element will then not be proved. So basically those are the role of the Department of Justice is basically to foot the bill for the assessment, because as soon as the court orders evaluation, then the Department of Justice becomes responsible for paying the professional who did the assessment. So basically, in a nutshell, that is the various roles and responsibilities in terms of the criminal capacity assessments.
So if I might just go a step back, in terms of the probation office, you said that it's not many of them are trained to do these assessments or reports. Is there a movement to train more probation officers or to get more people capable of doing such an assessment?
Look, as I said, the evaluation itself is a specialized field, and it's often difficult. And a lot of psychologists and psychiatrists, which I've dealt with in the past, have talked about this uncomfortable marriage between the law and psychology, because the law expects a black and white answer, and sometimes these things are gray, So I don't think it will ever be viable to train a probation officer because they will not be able to produce an evaluation report on the same level as a psychologist or a psychiatrist. There may be something that we could think about is just to point them, maybe insert, have certain things that they should be looking at. But as I said, sometimes, it's the way that the child acted before or during or after the crime itself. And that sometimes only comes out when evidence is being led in the court. Because when the probation officer do the assessment, they have an idea of the offense, but it's from the child's perspective. The child will tell them what happened, because they won't have insight into the police docket or have consulted with anyone outside of the child's family or the child themselves. So the purpose of the assessment is to get to know the child and the child's circumstances and to place that before court. So for them then to take it further and try and decide whether or not this child may have criminal capacity is something difficult to expect of them. I think what they can focus on, or what they may bring to the court's attention, if they feel that this child is developmentally behind children of his age, or issues that they have more training on, so which they can then bring to the court's attention, which then may alert the prosecutor or the court that there's something deeper, going on that they need to focus on and investigate further.
Thank you. I think that's very clear. It clears it up. Thank you. The reason why I asked that is there was a comment made by Erika Rabe in Denmark, and I'm assuming that this is something that happens around the world, but she commented that from her experience as a probation officer, there's a need for proper training to ensure a universal understanding around criminal capacity and assessment options, both for social workers and prosecutors at courts. I think this ties in with the previous question quite tightly. I don't know if there's any comments that you would like to make further to what Erika has said.
Look, as I said, there may be instances where the court have in previous occasions found that this child did have criminal capacity because he, after committing the offense, he ran away and he hid, no one could find him. He knew that, or he paid the younger child not to tell anyone if he maybe committed a sexual offense or whatever. So there may be some guidance as to what, things that you can take into account when doing this recommendation. But with the amendments, as I indicated, I think during the presentation as well, we are moving the minimum age of criminal capacity. We are in the process of increasing it to 12. And with that, we've done some amendments in the Act, where, the prosecutor, for instance, when considering whether they will be likely to prove criminal capacity or not, is to take the cognitive development of the child into consideration. And I mean, for a prosecutor, to expect a prosecutor to take cognitive development in, it's a difficult thing, So we have made some changes because of the uncertainty that, these various role players that have to consider or make recommendations or act on their on their understanding on whether the child have criminal capacity or not. So we are trying to remove that from the amendment. So I think when those are implemented, it will be clear that that is taken away from the probation of that specific issue, is taken away from the probation officers, because some of them, as I said, have indicated that they don't feel comfortable making those recommendations because of the nature of these evaluations.
So it's almost as if the amendments or what you're talking about now is actually working towards compartmentalizing the different sections of the assessment and actually having the correct person do that portion.
Yes, at the correct time. Yes, yes.
Okay, thank you. There was another comment made, and it ends in a question, so I will pose it. It's also by Erica from Denmark. She said, I had a struggle at my court where children were repeat offenders, 16 to 17 years old, were referred to CYCCs according to the Child Justice Act. Some of these children were considered children in need of care and protection, but due to a much longer waiting time and the age factor, it was a challenge having them placed according to the Children's Act. Our opinion was that in this case, it is better for a child to be in the safer environment of a detention center, as they would otherwise reoffend, but our judge disagreed releasing these children. Some of them were in court weekly with new charges, while the court still refused to refer them to the CCYC, saying a child in need of care and protection cannot be sentenced according to the Child Justice Act. Is this the correct interpretation of the Act by the courts?
Look, in South Africa, you get the CYCC is a Child and Youth Care Center, which they refer to. So if you look at the Children's Act, they use that as an umbrella for alternative care. So, a Child and Youth Care Center can be a place of safety. It can be an orphanage. It can be a secure care where your offenders go. So it depends on the program that specific center offers. So you get your secure care. It's your children that are awaiting trial or have been convicted, and then you get your places of safety or your orphanages or alternative care for children in need of care and protection. So so basically, the Child Justice Act provides for various points for the court to consider whether a child is in need of care and protection. It can happen during the preliminary inquiry, depending on the evidence or the information that's provided to the court at that stage. And sometimes this information only comes to light during the trial. So in those instances, the court can still stop the criminal proceedings and refer the child to the children's court to decide whether the child is in need of care and protection. And then if so, you know what to do with this child, whether it is to put this child in alternative care, an orphanage or a place of safety or a place that specifically deals with this child, even if it's a child that needs then a substance abuse treatment, or rehabilitation treatment, that's also a child and youth care, something that is referred to as a child and youth care and the youth care center. So and I think in those instances, there is a need to discuss this matter with especially your repeat offenders, because what's going to happen is they're going to end up in a child and youth care center for sentenced children, or in the criminal justice system. And if they're a bit older, they will go to prison if they're over 18 and they keep on committing offenses. The Children's Act is very clear that even a child that where the parents have difficulty controlling the child may be regarded as a child in need of care and protection. So I think there's a need to strengthen that part maybe of the probation officer's report to really highlight this and to refer the court to, you know, the sections in the Children's Act to make it clear that, you know, these children, or it may be because they are addicted to some kind of substance, that they are keep on committing offences, you know. So and if that is so, that also need to be emphasized in the assessment report, so that the court can then, you know, refer the child to the children's court with a view then of getting the child into a rehabilitation center. So I think you know, there's a need for the probation officer and the prosecutor to be able to liaise and discuss these kinds of cases, so that the prosecutor can then also guide the court, you know, as to the way forward. There may be instances, and as I said during the presentation, where the child committed a very, very serious offence, like a murder or a rape or something, but they are also a child in need of care and protection. Then it's difficult to, because the moment you acknowledge that it's a child in need of care and protection, they're taken out of the criminal system or the child justice system and placed in the children's court system, so that you don't prosecute this child anymore because they are a child in need of care and protection. So we are looking at strengthening the Child Justice Act in the sense that, you know, sometimes it may be necessary to refer a child to a children's court process whilst the criminal case is being dealt with, you know, so that you ensure that you look at the best interest of the child, because the welfare part is taken care of in the children's court, but you also then have your criminal case going on depending on the circumstances, because you also have to look after, you know, take the rights of victims into account and of society at large, you know. So to simply just take these children out without the consequences of the offence, because some people sometimes will argue that, you know, you get children in similar circumstances who never commit that kind of offence, you know. So you need to deal with each case on their own merits and taking the circumstances of each child into consideration. But there is a need for this process, this dual process, to go on, so that we don't overlook the fact that the child is in need of care and protection because we prefer to hold them accountable for their crimes. I think I hope that addresses the question.
I think so, and I think it's a very, very fine line to walk in terms of dealing with child offenders, and as you mentioned a couple of times today and in the presentation, that assessment is so important, so that it really needs to be a comprehensive and concise assessment that is conducted to ensure that the child receives exactly what is necessary in terms of if they are in need of care and protection, or if they do have criminal capacity. So it really, again, once again, falls on those people who are doing that assessment to ensure that they have conducted it in a way that highlights every single aspect of the whole situation.
Yes, no, I agree. That is very important, and that's what the Act emphasizes, the individualized approach towards each and every child. There's no one size fits all kind of approach, you know. Every child needs to be individualized and then decided on how to deal with that child.
Absolutely. Thank you. We have a few more, and two more comments I will ask. I will just post very quickly. And the one here posed by Sophia Stadler says, I also need to look into the timeframes for PIs to be held when a child is not in detention. So, since cases are sometimes prolonged for very long, not to the best interest of after a child has been assessed by the PO, or even arrested for cases long after they have committed the offence?
Yes, so the department is currently monitoring the finalization of preliminary inquiries as part of our annual performance assessments, or I don't know, they call it APPs, but which we have to report to Parliament, is, and that indicator falls within my mandate. So we are basically monitoring the finalization. At the moment, 90% of PIs are being finalized within 90 days after the date of first appearance. So most of them are, of this 90%, are finalized within the first appearance. So because when the case comes to court, the prosecutor have the assessment report, and they can immediately decide whether to divert the matter before PI or to recommend to the court that the matter be diverted. So as I said, 90% of them are being finalized within 90 days, but most are finalized within on the day of the first appearance. Sorry. So it is something that we are monitoring, and we do liaise, and that's where the intersectoral collaboration with the other departments come in very handy, because we are able to pick up that, for instance, in Soweto court, there's a lot of cases exceeds this 90 days. And if we look at the outcomes, then at the end, we realize that cases are postponed on lots of occasions, and then they are withdrawn, or then they are diverted after 200 days or 100 days or whatever. So in those instances, we do approach the NPA and say, listen, at Soweto court, we seem to have a challenge in finalization of cases because it takes a long time before they are withdrawn, or it takes a long time before they are diverted. And then the NPA will investigate and find out what are the reasons for the case being postponed on so many occasions, and the delay in the finalization. It may lie with police sometimes, that they don't complete the investigation and the case keeps on being postponed for further investigation, and then we can connect with police in those courts where we pick it up. But the general rule is, and I've said it in the presentation, the Act is very strict on postponements. You know, even for those that are not in detention, for those in detention, the case, and that's also in trial, not longer than 14 days in correctional facilities and 30 days in CYCCs. But if you look at the postponements of the PI, the court also said not more than 48 hours for this, you know, and not more than so many days for that, you know. So we are trying, the Act does try to eliminate unreasonable delays. But as I said, we also monitor it, and if there's instances or specific courts where this seems to be a real issue, you know, people can inform me about that, so that we can investigate, because it is in the best interest of children if this process is dealt with as quickly as possible.
Thank you. So there is a way for someone to inform if there has been an undue delay in any sort of action in a certain case.
Yes, we can investigate it, and it depends. Look, you still have the discretion of the prosecutor, and you still have the judicial discretion. So we cannot necessarily interfere into those discretions. But as I said, if you have a court where it happens often with a lot of cases, then it's something that you in general can then investigate, not to interfere in a specific case, because you know, the department don't have a mandate to interfere into the discretions of the role players who's in control of the prosecution itself.
Absolutely. Thank you. I just have another comment here, and then I'm going to close with our final question. The comment here was by Helen Jack, and she says that in our area we have primary school learners smoking. School disciplines them by sending them home for 7 days, drags it to 20 days and longer, causing dropouts to increase sharply. Now, surely, I mean, this is a situation that is part of the education department as well, is it not?
It is, and I think you know, the education department, you know, there's a need then. Sorry, the person who posed the question, is that a probation officer, a social worker?
Let me just double check here. It doesn't really say what her title is.
Okay.
She's from an organization called Ubuntu Sprunkles Sisters.
Oh, okay. So basically, what you know, the school needs to then, you know, rope in a social worker to investigate the circumstances of this child, and then, you know, in consultation with the parents, then, you know, refer the child to the children's court, because that may be a sign of a child that is in need of care and protection, because maybe the parents don't have control over that child, or the child is not even staying with parents, you know, that he may be in a child-headed household, or, you know, being left to his own devices. So I think there is a need for the school to interact with the social worker, so that those you know, those issues can be investigated. And as I said, you know, we talk about substance abuse, or people being addicted to substances, but we often forget substances include tobacco. Nee? And that's something that we need to then focus on, to say, but you know, this child is smoking maybe at school or during school hours because he's addicted to nicotine, not because he's being naughty or whatever, and that falls under being addicted to a substance. So and you need another kind of intervention. Obviously, the expelled from school for a week or two doesn't work, because there's an underlying reason why this child often smokes at school, because he's addicted. So there are, and it can be an inpatient or an outpatient program that the child's being referred to through the children's court, and that's something that they might have to look at.
Hmm. Yeah, so there are, I mean, there are alternatives, and I think that is something that it seems like a very interesting webinar for ISSUP and ITTC as well, is to get someone to talk about alternatives to suspension or expulsion from school for children who have been identified as substance users, or to be able to create access to treatment or something for these children.
Yes, and you know, even if you discipline a child in terms of the Schools Act, the South African Schools Act, part of that disciplinary process can be referral to therapy or counseling, you know, to address the root causes of this child being, you know, not doing what they are supposed to be doing at school. So I think we tend to look at the punitive part of, you know, of the disciplinary process, but I think that should include the, you know, supporting the child as soon as you realize what are the reasons for them, and maybe you can then have a suspension, you know, suspending conditions. So if they you know, kind of do the therapy or the counseling or whatever, they will not be expelled from school for a week or whatever, you know, so that the child have some control over whether he's going to comply or not. And if not, then whatever happens after that is then his own, you know, out of his own volition. So
absolutely, thank you. I definitely feel that that's something that we at ISSUP will look into and see if we can organize something like that. Right. So, Dr. Badenhorst, I'm going to close with the final question that was posed by Marvelous Chinawa from Sanke in East London. And she asks, I just want clarity when it comes to cannabis control and the right to privacy when it comes to children.
Okay, so I referred in the presentation that the court found that various rights of the children were infringed upon, referring to the right to equity, equality, the right to privacy, etc., etc. So when I saw this question, I also went a little bit deeper, because it's an interesting question to ask. And what I realized is it was part of this order, and the court was referring to the way that these 4 children, which brought this, where this case emanated from, was referring to what happened to them. So in terms of the Schools Act, if a child is suspected, or there is a suspicion that children are bringing dangerous weapons or are using or possessing drugs during school time, they can ask for a search, and that search is then done on condition that whatever they find should not find its way to the criminal justice system. So then you can only have the disciplinary part of the in terms of the Schools Act, and then the outcome of these tests. So if they suspect a child have been using cannabis, for instance, and they do a drug test, the outcome of that is supposed to be confidential. So with these children, what happened is the outcome was made public by calling the police in, which was not supposed to happen in the first place, and then taking the children through to the court. So the confidentiality was then breached, in this instance, and that's why the court said their privacy was being infringed on, because the results was made public, and that is not the reason. So in that context, that's why the court indicated that that there was a infringement on their right of privacy. So it's not in general, if a child uses cannabis, or we lock them up in general, that there will be a infringement on their right of privacy. It was in context of this specific case.
Thank you. I think that it is a very interesting question, and opens up an entirely different avenue of investigation, because with the new Protection of Personal Information Act, with the amount of troubles that the schools are having in terms of substance use, and how do they navigate as a school body and ensure that the child's privacy is looked after, but how do they also ensure that the discipline at the school is ensured? It's quite an interesting area.
Yeah, so I've also looked at the Prince case, where the Constitutional Court declared the use and possession of cannabis by adults unconstitutional. And there the court also indicated that there was a infringement of the right of privacy of adults. But the court made it clear that it's not, it's because the respondent, so that is now the state, if I can call that, did not be on a balance of probabilities indicate that the limitation on the right of privacy is justifiable in what are you doing in your own home when you are smoking cannabis. But the court made it very clear that it's only limited to that specific issue of using it in your own home. So it's not a generalized. So the court was very clear to indicate it's only in this instance, because they could not justify, because you can infringe on someone's constitutional right if the limitation is justified in terms of section 36. But because they could not justify the limitation on the right to privacy to use cannabis in your own home, You know, that is where the issue of privacy came from in the Prince case. But in this case, it was with regard to the way that they've dealt with the outcome of the results, which was not supposed to be made public. So I think when we get the Constitutional Court judgment in relation to children, it will also be a very interesting exercise to go through the judgment to specifically understand, you know, how the court arrived at the specific, you know, what the court took into consideration when arriving at the judgment that it's going to hand down on this issue. So I think that might be something that, you know, will provide a lot of insight, you know, and I emphasized it in the presentation as well. We must just be very clear that all the ministers that participated in this case in the Gauteng court emphasized the fact that that they agree that the use or possession of cannabis should be decriminalized. But it's not because we are condoning or encouraging children to use it, or we don't see any problem in respect of children's health or development when they are using cannabis. The sole reason is that there are less restrictive alternatives to deal with these children outside of the criminal justice system. So that is, and I think that is something that, you know, it's important for members of the public to understand. It's not like, you know, we've thrown everything to the wind and we say it's fine for children. The reason is we want to protect children by not locking them up for using cannabis. We rather give them the support and interventions that they really need to be able to deal with their addiction.
Absolutely. I think there's a lot of work that still needs to be done around this whole topic, and there's a lot of understanding that we need to establish, even us who are practitioners in the field, and how do we navigate the new decriminalization and the legislations and all of that. And you know, it's really about time and finding the correct way of moving forward with all of this.
Yes, no, I agree with you.
Absolutely. So, Dr. Badenhorst, that brings our questions to an end. I just want to double check that I have gone through all of them. Yes. I want to thank you, Dr. Badenhorst, so much for availing your time once again to respond to these questions. Really, it has been thoroughly interesting for me to sit here and listen to you, and we would love to invite you back as a follow-up at some point. So ISSUP will definitely be in touch.
Thank you very much. And as I said earlier, thank you for the opportunity. It's always a great privilege to be able to share this information to make people aware, you know, of what we do have and how we can support, and you know what we and how we, you know, how important it is for all of us to protect the best interest of children. Thank you so much. I really appreciate it.
It's only a pleasure, and we look forward to having you back. Yes. And thank you to our listeners, and just a reminder that if you have not registered as an ISSUP South Africa member yet, please do so by logging on to www.issup.net. We also want to, as ISSUP South Africa, thank the ITTC network, particularly ITTC in South Africa, for all their support in running this webinar and hosting the webinar with us. Without ITTC, we would not be able to conduct these, so we are very, very grateful for that partnership. And to all of you out there, thank you for your interest and for the questions posed, and we hope to see you again in our upcoming webinars. Thank you very, very much.
Thank you.
Thank you.